Welcome students to this video series on incorporation. Business associations begins with the meaning of business, but businesses themselves begin with the incorporation process, which is what we're going to talk about in the next series of videos about how to actually start a new business venture in the form of a corporation. In this video series, we're going to cover 3 topics involving incorporation. The first being incorporating a Delaware corporation and some of the decisions involved in whether or not to incorporate in Delaware or elsewhere, and then the process of how to go through that. 2, defining corporate powers. There's a doctrine called the ultra vires doctrine, which states that if a corporation acts outside of its corporate powers, that action is unlawful. We're going to try to avoid that. And third, speaking of lawful activity, as lawyers, we need to think about legal ethics. Legal ethics come into play in incorporation in some unusual ways because we're representing a situation, not necessarily any individual people, although they may think we represent them. So we're also going to need to delve into some of the legal ethics of incorporation to really understand the lawyer's role in this process. When you form a business for multiple parties, who is your client? Ethically speaking, after the corporation is formed, the lawyer represents the corporation. But before the corporation is formed, things are a little more complicated. So we have some special ethics of incorporation we need to deal with presently. Because until we've actually formed a company, we are in front of people and representing a situation which hasn't existed yet. I think the best way to understand this is to go through a few simulations and to see how they play out. Maybe analyze them a bit and see if that helps us get some intuition around the lawyer's role and the special legal ethics of incorporation. Here's simulation part 1. So you represent Basil. You've represented him before, and he asked you to help him form a corporation for a new beverage business. And he'll be joined by Sybil, who will handle the finances, and Gowan, who has the money. So you're a corporate lawyer. Who do you represent? Do you represent Basil, who you represented before? Do you represent Sybil and Gowan, who you haven't met yet? Do you represent this business? And if so, what does it mean to represent a business that doesn't exist? Whom do you represent? Think about that for a minute. The answer depends in part on whether we apply an entity or an aggregate theory to a business association. Under an entity theory, that the business is its own separate entity, the lawyer only represents the entity. This is easy when the corporation is clearly separate from people, like Microsoft, some huge corporation out there. It's got its own business, and it's had multiple CEOs. The original founder no longer is even involved in the business anymore. And so it feels very much like a separate entity, and its managers treat it like a separate entity. But sometimes a business appears more like an aggregate of individuals, especially when it's a partnership, especially when it's a partnership of the people that founded it. In fact, it's more likely that a partnership aggregate theory would apply, and one might reasonably think a corporation or business is like an aggregate of individuals unless its own entity, when it involves few participants. And that's when things get dicey. So here you are at the beginning of representing a brand new firm. You have human beings in front of you. Technically, you don't represent them. You represent the business that doesn't exist yet. But conceptually, that's hard. And so we tend to apply the aggregate model, whereas the business is a sum of its parts, when thinking about our rules of professional responsibility in this situation. The model rule of professional responsibility 1.13 discusses the organization as client and says that a lawyer employed or retained by an organization represents the organization, acting through its duly authorized constituents, meaning the lawyer does not represent the authorized constituents, but rather the organization itself. So if you're talking to the CEO of Microsoft, you don't represent the CEO of Microsoft, you represent Microsoft. And that's important because their interests may not always be aligned. Sometimes an attorney gets information about those misalignment of interests. If an attorney, if a lawyer for an organization knows that its agent intends to violate a legal obligation, the lawyer shall and must refer the matter to higher authority in the organization, including to the board of directors. So you're sitting there with the CEO. He tells you something private that could harm the company. You now have a duty to disclose that. And this is tough because you might also think you have a duty of confidentiality. You're sitting there across from your old friend. You incorporated this business with him 35 years ago. You've been friends for 35 years, going out to church after church together for 35 years. And here's a person who is now telling you that, let's say he has cancer and may no longer be able to run this company to the best of his ability. Well, now you may, as the lawyer to this firm, have a duty to disclose that private information about your close friend to the board of directors, because you have an obligation if this person intends to abdicate their legal duty of care, for example. If, despite the lawyer's efforts to act in accord with paragraph B, meaning if reporting up doesn't work, and the lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, the lawyer may reveal the information relating to the representation. So a limit here to our duty of confidentiality, even. That's pretty important. One might say that the lawyer in these cases is not the lawyer to a party, but in the pre-incorporation phase, you're the lawyer for the pre-incorporation situation. There's no client yet. The client hasn't been formed yet. So in this inaugural phase, where the corporation doesn't exist yet, all the parties involved compromise the situation. And so your goal is to make the situation occur as efficiently and expediently as possible. And so that may be your strategy here. Just to how do we get to this collective goal of having the business exist as soon as possible so that you can begin representing something tangible. To do this effectively, you, the lawyer, must make clear to the parties at the outset that you do not represent the individual founders. And I recommend putting this directly into your engagement agreements. The contract that you have with your clients. I don't represent you, human beings. I represent an entity you're going to form, and have them sign to that. Let's take another look at a simulation and see if the obligations that we have from past dealings continue as we obtain new representation. Because one way we get business as lawyers is through referrals, through our network. So here, what if we actually had represented Basil in his divorce settlement? And Basil says to you, as you know from your work for me on my divorce, there are some pretty personal things I've told you. I assume you won't be telling the others. Under his breath, he adds, I'm really strapped for cash. With what child support and alimony, I'm not sure what to do. But with this new company, I plan to get out as much cash quickly as I can. So has Basil now presented you with a conflict of interest? Right? Let's read those words. Basil has just, in confidence, treated you as if you are his lawyer. Whose lawyer are you? Well, either the new company, which doesn't exist yet, or the situation. So now the situation is in peril because Basil wants to extract cash from it. What are you going to do? Model Rule of Professional Responsibility 1.7, Conflict of Interest, discusses this situation. A lawyer shall not represent a client if the representation involves a concurrent conflict of interest. But such a lawyer may represent such a client if the lawyer provides competent representation, if it's not prohibited, if it's not involving the same litigation, etc. What are you going to do here? The rule is that you can't represent Basil and the company anymore. What should you do? Well, you already were Basil's attorney. You still represent Basil. His confidences to you during the divorce cannot be disclosed to others without his consent. You are primarily his lawyer. He has paid you for his services. You have taken him through his divorce. Your obligation to him continues. Can you represent the corporation? No, I don't think so. I think Basil's comment has just caused you to lose this corporate client. The way to resolve this conflict is unfortunate, but Basil's interests and you represent him are at odds with the corporation's interests. And according to Rule 1.7, you can't represent both. Can you resolve this situation? Maybe. You would have to disclose that Basil is planning to loot the corporation, which means you have to ask Basil to allow you to do that. If telling others that Basil plans to loot the corporation would violate your obligations of confidentiality to Basil, and I think it would, you must withdraw from that representation. And you can't tell the others why. So what happens here? I think you have to withdraw. I think Basil's statement has caused you to be in an irreparable bind where you have to represent him and no longer can represent the corporation without disclosing his confidence, which you cannot do. You can't say why. You're ethically bound to maintain that confidence. See Rule 1.6 states that you cannot disclose the reasons for this withdrawal. Sybil and Gowan are going to be confused, and you're just going to have to tell them to look for another lawyer who may be able to explain what's happening. Unfortunate, but that's how that's going to go. You don't represent the corporation yet, and you did and do represent Basil. And when his confidence is directly in conflict with the corporate need, the corporate exigency, you can't represent both. Situation 3. Gowan walks in. He says, "Thanks for explaining that you'll help form a corporation. As you know from my son, Gowan Jr., he's pretty unsure about his future. I'm investing in this company, so there'll be a place for him. I'd like you to draft the papers that give me voting control, but Basil and Sybil don't have to know. Please hold us in confidence and draft the papers as I want. As you know, I'm paying your bill." So in this situation, the ostensible CEO is coming in and asking you to do something that directly benefits him and his son at the expense of the corporation. This is not related to any previous representation, but apparently Gowan thinks that you have a special relationship with him and he can tell you these things and he's going to take care of you, I guess because he is in charge of the finances. So what do? Can you honor this request and draft this in confidence? Should you? What do you do here? You cannot follow Gowan's directive. You are not permitted, as an officer of the court, to help him act adversely to the corporation, your client. Doesn't matter who's cutting the check. He's just an agent. He's just signing the check. He's not the bank account. You cannot follow his directive. You cannot act adversely to your client, the corporation. If he persists, you may have to tell the others about his plans. And moreover, you can. Any disclosure you make about Gowan's plans are not related to any prior representation. So you're in a much better situation in terms of your ability to actually disclose what's going on here without losing representation of this client. In summary, incorporation is a relatively simple process. All you need to do, technically, is to fill out a very simple form with some basic information. And then you should help the company hold an organizational meeting where they handle some of their basic introductory matters, such as issuing the first stock, appointing the directors and officers, etc. But it gets tricky because on a personal level, you're face-to-face with human beings, and you're representing a situation that doesn't even exist as an entity yet. So to do this properly, you should have a very clear engagement agreement where the participants, meaning the founders, understand and give consent that you represent the situation and the future business and not them. Any confidences by participants are not necessarily protected so long as you disclaim your obligation to represent them. If they think you're their attorney, that's a bigger issue. But if you've done a good job in your engagement agreement of distancing yourself, you should be all right. Now, if one of these people came to you from a previous engagement and that creates an irreparable conflict, you may have to withdraw from the representation. Fortunately, most people don't find themselves in the situation because most people do not do both complex incorporations and divorce work, as the example gave here with a client who you had worked on a divorce case and now was incorporating in a business. But if it were to happen and one issue conflicted with the other, you have to honor your confidentiality obligations to your client, which may require you to withdraw from the representation. Hopefully that doesn't happen to you, and a well-drafted attorney engagement agreement can help prevent that situation in the first place.